Hello, good evening, everyone. I'm Amir Kumar, Senior Associate at King Stub and Kasiva, Mumbai office. I practice litigation and dispute resolution. So today we are here to discuss the topic payment obligation of the tenants during the lockdown. As we all know that due to the COVID situation and the countrywide lockdown, a lot of issues has been arising between the landlord and the tenants, and many companies and the corporates they are not able to use their premises, their office premises. And in that context, we need to analyze that whether they are liable to pay their rent during this lockdown period or not. So, in order to analyze those aspects, we need to understand few legal principles, few provisions under the law, which we are going to discuss today through the slides which I have prepared. So, moving ahead with the slide. So the first slide is assessment of your contract. So here it is very, very important to identify the first thing, that is force majeure clause. The force majeure clause of the agreement. So from a contractual point of view, the force majeure clause relieves the party from performing its contractual obligation upon occurrence of any force majeure event. Force majeure is nowhere defined in the Indian Contract Act. However, the reference has been taken is given in section 32 of the Indian Contract Act, which is called as the contingent contract. The contingent contract provides that if a contract is contingent on the happening of the event which becomes impossible, then the contract becomes void. Force majeure clauses could be of two types. It could be illustrative or a specified. So we need to understand that in illustrative form of clauses, it forms the wording of the clause with the illustrations therein. So the wordings could be like that on the event of or on the occurrence of any event, as such as due to act of the god, due to war, due to flood, due to earthquake, or any accident or any irresistible force causing damage to the premises. So here the wordings are little different. It is in the form of illustration. The wordings starts with on the occurrence of any event, such as due to act of the god, or due to the earthquake, due to the flood, or due to any other force which causes damage to the property or the premises. So in such cases, in such clauses, the intention of the parties are taken into the consideration to analyze the events, the examples, to analyze the examples, what was intended to convey by the clause. And in the other specified clauses, the events are usually very, very clearly specified and contemplated in the contract, which would constitute a force majeure events. So in such cases, it is totally depends upon the wordings and the language of the clause to interpret and analyze the force majeure event. The force majeure event which has occurred, that has to be specified and that has to be in the term of contract in order to invoke such clauses. So now with the COVID-19, the lockdown perspective, it is important to figure out whether such pandemic events or the events by act of the government resulting into the countrywide lockdown, whether such things are expressly contemplated in the contract or expressly constitutes a force majeure event or not, and do such events under the contracts entitles you to seek the suspension, waiver, or any sort of deferment in the rentals. If those things are covered, if those such events, uh, such things, such suspension or such waiver or such deferment in the rentals, those are covered in the contract in your force majeure clause, then a party can invoke such clause to seek the relief in the terms of the rentals. The same will be governed by the section 32 of the Indian Contract Act. Therefore, the relief based out of the force majeure clause are totally depends on the wordings and the language of the clauses. While invoking such clause, it is very important to analyze whether such invocation of such force majeure clause would result in the termination or makes the contract void. Then in that case, also the bear in mind that they might have to surrender the premises or hand over the premises back to the landlord. And in the case if they wish to continue the possession of that premises, then in that case the rentals and the charges under the agreement would be again paid for them. So this is the understanding about the force majeure clause, which is very, very important to analyze and assess under the rentals agreement. Now the rentals agreement are of generally two types, which is lease and the license. However, there is a difference which we need to understand, the huge difference between the lease and the license, both the agreements. So in the lease, the landlord transferred the right and interest in the property. So lease is basically a transfer of right and interest in a specific movable property. However, in a license is a bare permission to use the property without any transfer of the interest. Now the rights and interest which are getting transferred, which gets transferred in the lease through the lease deed. So those rights and interest could be like subletting the property, or to enjoy the property, to manage the property, or to destroy the property, to enjoy the fruit from that property. But in the license agreement, the licensor promise and ensure the continuous uninterrupted access and the availability of the premise. In this license agreement, they are not transferring the right and the interest in the property. Therefore, to seek the relief from the payment obligations, it is very, very important to assess the contract in respect of the lease and the license agreement. We should look into the agreement irrespective of the nomenclature. One should identify the nature of the contract, nature of the agreement, whether it is just a permission, a bare permission to use the property, or is there any right and interest in the property are being transferred in the agreement. Because it is settled that the terms and the agreement will prevail in any case, irrespective of the nomenclature. In quite a few cases, we have seen that the agreement has been termed as a lease. However, under the clauses, under the covenants, there is no transfer of the rights and interest in the property. So technically, such agreements are the license agreements only to use to use the property, to have the access of the property. But those agreements are still termed as a lease agreement. So the party shall check the agreements very closely that whether there is a grant of lease or the license, because both the agreements are governed by different laws. So this is about the assessment of your contract, the force majeure clause and the rental deeds, the rent agreements. So now the next slide, we are talking about the few principles of the contract, which is very, very important and required to understand here. The first is the doctrine of frustration. So the doctrine of frustrations comes into play after formation of the contract, when a contract becomes impossible to perform on account of any circumstances beyond the control of the parties. So the wording of the section 56 provides that an agreement to do an act impossible in itself is void. So it says agreement to do an act impossible in itself is void. It's not void devil, it's void. So therefore the party must bear in mind that upon invoking the doctrine of frustration, the contract will be considered as terminated. It cannot be continued after a specific period or after a period of uncertain or unforeseen event. So it is very much required that the performance of the contract has to be absolutely impossible, and there must be some change in the circumstances due to an unforeseen event after the formation of the contract, which shall render the performance impossible. Because merely saying that the contract is impossible to perform or the cost has risen, and that's why that the contract is now impossible to perform. So those merely just saying that the contract is impossible to perform, that would not constitute the frustration of the contract. So in the absence of force majeure clause in the license agreement, if we talk about the license agreement and if there is no force majeure clause, then the licensee can claim the frustration of contract as per 56 of the Indian Contract Act, section 56 of the Indian Contract Act, and that can be claimed, and that can be used as an excuse from performance depending upon the facts and the circumstances. However, upon invocation of the frustration, it would be very, very difficult for the licensee to use the premises after the lockdown is lifted, as the agreement stands void in terms of the 56. Now, it is further important to understand that the doctrine of frustration would not be applicable to the lease agreements, because it is a settled law that section 56 of the Contract Act is not applicable when the rights and obligation of the parties are under a transfer of a property, because that defines a lease of immovable property as a transfer of a right to enjoy such property. Therefore, in case of lease agreements, the tenants, the lessee, cannot claim protection under the doctrine of frustration. Now, the next doctrine is the doctrine of reciprocal promise, which I have mentioned here. And the reason for discussing this doctrine of reciprocal promise is that because I think it can be an alternative defense for the licensee, for the tenants under the leave and license agreements. So this can be used as an alternative defense or as an excuse from the not paying the license fee or any other charges for the period during which the license premise cannot be used. So it is important to understand that the doctrine of reciprocal promise, it is given under section 51 and 52. The 51 speaks about the simultaneous performance, and the 52 is the sequence of the sequence performance. So the doctrine of reciprocal promise construes that if any other party is not ready or willing to perform their promise, so the readiness and the willingness, it is very important here. If the other party is not ready or willing to perform their promise, then the other party does not need to perform their side of promise. So it can be concluded in a way that if the licensor under the agreement has agreed and promised me to provide the uninterrupted access to the license premise on a monthly fees, but What if he failed to fulfill his promise? What if he failed to provide me the uninterrupted access to the licensed premises? So in that case, I think I have not been provided, if I have not been provided with the said access to the my premises, which he has promised, then I need not to perform my side of promise to pay the license. However, again, this doctrine of reciprocal promise would not apply to the lease agreements because of the same reason as discussed in the context of the doctrine of frustration. And for the settled reason, the principle of contract would not be applicable in lease, where the rights and obligations of the party are dealt under a special law, that is transfer of property. So moving on to the next slide. So next is section 108 of Transfer of Property Act 1882. So this provision is in the terms of lease agreements because it is governed by the Transfer of the Property Act under Chapter 5 of the Act. And it discuss about the section 108 specifically, it discuss about the rights and liabilities of the lesser and the lessee. And 108E that provides the obligation under a lease that can be discharged at the option of lessee. Now, when it can be discharged when an unforeseen event destroys either the entire property or material part of the property, or an unforeseen event that makes the property substantially and permanently unfit for the purpose of which it was it was left. So therefore it is important for the tenant, for the lessee, to establish that a material part of the property is destroyed, or that part has been rendered substantially and permanently unfit for the use by the lessee. So that to seek relief under this section 108E, there it is important to establish that the property is completely destroyed, or a material part has been destroyed, or has been rendered substantially or permanently unfit for the use, and so on. So it is also important again that the tenant should first bear in mind that this relief under 108E that voids the entire agreement, unlike the section 56 frustration under the this Indian Contract Act. And consequently, a lessee will again cannot continue the use of the property after invoking the option under this 108E of the Transfer of Property Act. The lessee will have to hand over the peaceful vacant position of the property to the lessor. And if he fails to hand over the property, and if he is again using the property, then he will be liable for the rentals. Now, under this section, in this context of the present COVID-19 and the lockdown situation, so this section would not be applicable, I think, because as the enforced lockdown, that does not meet the criteria for invocation of 108E. And the lockdown has neither the lockdown or the pandemic have resulted in the destruction of the leased property. So it cannot be claimed that lockdown has left the property permanently unfit for use, or a material part. So under this section, it cannot be claimed in context of this COVID-19 and the lockdown. And further, an unforced suspension of the business for a limited period of time cannot be said to have rendered the property substantially unfit for the purpose of the lease. So these are the principles under the transfer of property law and the Contract Act. Now moving forward with the next slide, which is case laws. So few important case laws which I have want to discuss here is the first is the this Marwanji Kama versus Sayyid Sardar Ali Khan. This case was highlighted when the plague hit the India, and in that in 1899 case, the single bench Bombay High Court has held, said in that case. So actually, what happened in that case? The defendant was obliged to vacate the premises under the notices from the plague authorities. And then in the suit for the arrears of the rent, the defendant pleaded that he was not liable for the rent for the period he was out of the possession due to the notice of the plague authorities, and as his enjoyment of the leased property was interfered. So the single bench Bombay High Court held that when under the provision of Epidemic Act, it become unlawful for the tenant to occupy the premises in the manner contemplated by the lease. There was no breach of the lessor's contract for quiet enjoyment by the lessee, and therefore the tenant was not relieved from the payment of the rent. The next case is Raja Dhruv Devchand versus Raja Harmonder Singh. It is a very, very important and very famous case with respect to the force measure, where in this case the Supreme Court was called upon to decide whether Section 56 of the Indian Contract Act is applicable when the rights and obligation of the parties have been earnest under a lease deed. In this case, the three-bench judge of Supreme Court held that the frustration Section 56 of the Indian Contract Act won't apply to lease deed, and the court observed in the para 17 of their judgment that under a lease of the law there is a transfer of the right to enjoy that land, and if any material part of the property be wholly destroyed or rendered substantially and permanently unfit for the purpose of which it was let out because of the fire, tempest, or flood, violence, or any other irresistible force, then the lease may be at the option of the lessee be avoided. So this rule is incorporated in 108E of the Transfer of Property Act and applies to the lease of the lands, to which the Transfer of Property Act applies, and the principle thereof to the agriculture leases and the leases in the areas where the transfer of property is not extended. So where the property leased is not destroyed or substantially or permanently unfit, the lessee cannot avoid the lease because he does not or is unable to use the land for the purpose of which it was let to him. Moving on to the next case, that is uh, Dhan Rajamal versus this Samji Kalidas. So in this, Supreme Court was observed that where the reference is made to the force measure, the intention is to save the performing party from the consequences of anything over which he has no control. So the court also construed that the interpretation and the applicability of the force measure clause depends upon the language of such clause which was in contemplation of the parties at the time of formation of the contract. So this in this case. Moving on to the next case, it was passed by Madras High Court, Alandurajapur versus Hamid, VTSA Hamid. It is 1962. It was passed by Madras High Court. So in this case, the Madras High Court, while dealing with this case, the Madras High Court has rejected the tenant's claim for remission of the rent on account of the two cyclones that has caused suspension. In this case, the court held that temporary suspension of the business caused by the cyclones in a 5-year lease agreement would not frustrate the contract. Then in Energy Watchdog versus ECR and others held that it was held that in that case that the contract itself contains an express or implied term relating to the force majeure conditions. The same shall be governed by Section 32 of the Indian Contract Act and Section 56 of the Indian Contract Act, which deals with the impossibilities of the performance, would apply in cases where a force majeure event occurs outside the contract. If a contract if a contract has an express or implied force clause, it will apply over the principal under Section 56, and the force majeure clause will not apply if any alternative modes of performance are available. Now the Ramananda and versus Ramananda case versus D. Girish Soni, it is a very recent case in which Delhi High Court has passed a judgment on 21st May in this year only. And in this case, the Delhi High Court has discussed the issues between the tenants and the landlord and the arisen due to this COVID-19. So these issues are dealt by the Delhi High Court in this recent order. And in this case, the court says that court has held that the courts can consider applicability of 32 of the Indian Contract Act only in a circumstances where a force majeure provisions are included in the contract. So if there is no force majeure clause, then 32 will not be applicable to such contracts. Then the Delhi High Court has also reiterated that the well-established position of non-applicability of Section 56 of Indian Contract to arrangements of lease and other similar situated contracts. It was settled. The court has cited many Supreme Court judgments also in this case, and it was settled that the Section 56 of the Contract Act does not apply to the cases in which there is a complete transfer, and which is also held in the case that Raja Dhruv Dev Chand versus Raja Harmander, which we had already discussed. So this recent Delhi High Court, while its judgment has also clarified that 108 of Transfer of Property Act, which embodies the doctrine of frustration, will govern tenancy and the leases in absence of the force majeure in the lease deeds. The remedy in the section 108 of transfer of property is for the lease as void at the option of the lessee if the events contemplated therein occur. Under no circumstances one can take the recourse of 108 of TPA, Transfer of Property Act, to make a case of suspension of rent. So, in this Delhi High Court judgment, they have the single bench judge has relied upon various Supreme Court rulings and also held that 108 of Transfer of Property Act would not apply in the absence of contractual stipulation on a force majeure, and that too where there is a complete destruction of the premise, or when the premise are rendered substantially or permanently unfit for the purpose of use for which it was let. It is also constituted through this case that temporary inability to use the premises by a tenant due to the lockdown would not entitle the tenant to avoid the lease under the 108 of transfer of property. For that matter, even suspended payment of the rent. So this Delhi High Court judgment is very much in discussion in this context, and so we will have to wait and watch what other high courts and how other high courts are interpreting these issues, and what decision they are going to pass in such disputes between the landlord and the tenants in context of the COVID-19 lockdown. And then coming to the next slide, it is a probable solution, wherein the solutions are concerned with respect to these disputes. So the first thing which I have discussed, that the tenant should analyze first the force majeure clause carefully in their agreement, and accordingly they should move forward. First, they should understand whether such events, such situations are covered in the force majeure events. What all situations are constituting a force majeure event, and is there any entitlement of seeking waiver of rent or deferment or the complete waiver? Are those things are entitled? Are those things are mm, there in the contract? So that has to be looked upon. So second thing is that you can communicate to your landlord, the lessor, the licensor about the inability to pay the rent, and the reasons. What are the reasons for the inability to pay the rent? Tell them, communicate to your landlord, speak with them, tell them about that you are not able to use your premises due to this imposed lockdown, and if any loss has been suffered by the company or the corporates, just tell them that this due to which there is a halt in the operations of the business, and we have suffered a loss. Let them give them a data, what exact the data is, how much the loss you have suffered. Just provide them and with the supportive documents. So, and better with this context, you can communicate and negotiate with the landlord. And then I think negotiations would only work in this case, and how better you can negotiate with the landlord. And then, in the worst case scenario, you can negotiate and agree to a reduced rentals for a period of lockdown. And after, once the lockdown is lifted or the situation comes to normals, in that case, then again you can come back to the normal arrangements and the normal rentals. Uh, so now it is over. Thank you. And now, if you have any questions, please let me know. So I could not see any questions. If there is any questions in the chat box or anything, we will come back to you with your questions offline. And
Sir, we
I
have
would
no
like
no questions as such, so I think we can wind up the session here with thank you remarks, I think.
sure, Pawan, sure. So I would like to thanks to all for taking out the time and for hearing this session, and would like to thanks KSK for giving me this opportunity to speak through this webinar. Thank you, and stay healthy, stay safe. Thanks. Bye.
Okay.